Hi there. Welcome to the third episode of the Utsav Mukherjee Intellectual Property and Technology Law Show. For those of you who are watching my show for the first time, I am an intellectual property and technology lawyer based in Delhi and I'm affiliated with the law firm here. I have launched this video series to spread awareness on intellectual property and technology law developments in India and around the world. And any views or opinions that I express during this video series are mine alone and not that of any other person or entity. So today's episode is about the law on privacy as it stands today in India and the latest proposed bill on the same, which is called the Digital Personal Data Protection Bill of 2022. So you must have heard many times that data is the new oil. I in fact say that it is not only the new oil, it is the very fuel that is driving industries and companies in today's tech-driven world. So, with the growing relevance of this new empowering tool called data, lawmakers around the world are framing elaborate policies to regulate how data can be collected, stored, processed, or used, or even transferred for that matter. So, the right to privacy was first recognized as a fundamental right by the Supreme Court of India and the landmark Puttaswamy judgment of 2017. And ever since then, bill after bill has been floated by the central government on privacy, and committees have been formed to deliberate upon privacy issues and draft appropriate laws or policies to regulate this. But all of these are just bills which haven't yet been enacted or put in force. And the latest bill, which is also not yet in force but is only a proposal for the law that could be enacted on privacy, is the Digital Personal Data Protection Bill, right, of 2022. So, the Ministry of Information and Technology, which we commonly refer to as the MIghty, had released this bill in December 2022, and it had also invited recommendations from stakeholders to give their suggestions on how this bill could be improved or something of that sort. So, as an intellectual property and technology lawyer, I was keen to send in my recommendations on this bill. And while I liked the bill's lucid form, there were certain aspects on which I felt there was room for fine tuning. So, in today's episode, I'm going to discuss the existing regulations on privacy in India, the proposed new bill, and the recommendations that I had sent to the Ministry of Information and Technology on this bill. So, first of all, I'll tell you about the statute which deals in India with IT laws, and this statute is called the Information Technology Act of 2000. So, an amendment was made in the year 2009, which incorporated an important section into this IT Act or the Information Technology Act, and this section was called Section 43A. So, as per this section, any body corporate which has any sensitive personal data or information in its possession fails to put in place reasonable security practices and procedures to safeguard such data would be held liable for any loss that is caused to any person for theft of that data or breach of that data. So the first question that probably comes to your mind is what in the world is sensitive personal data or information, right? The sensitive personal data or information, which is commonly called as SPDI, is defined under the SPDI rules, which is put in place under the Section 43A of the IT Act. So SPDI rules define sensitive personal data or information as certain specific kinds of data which are more personal and sensitive in nature, such as passwords, bank accounts, information about one's sexual orientation, medical records, things of that sort, which are not very, public details that you would share with, say, random strangers or even a lot of your friends. These are very, very personal details. And that's why they're called SPDI or sensitive personal data. So, Section 43A of the IT Act and the SPDI rules are currently in force. However, if the Digital Personal Data Protection Bill of 2022 is adopted in its present form, Section 43A of the IT Act and the SPDI rules will both be omitted. Right? This means that they won't be in force anymore. So, let me first tell you about the recommendations which I sent to the Ministry of Information and Technology or the MIghty on parts of the SPDI rule which are sought to be replaced or omitted by the new bill. So the SPDI rules that are currently in force require that a privacy policy be enacted by entities which collect or store data. And this new digital privacy bill, however, does not require such a privacy policy to be put in place. And this is a cause of concern as privacy policies are necessary not only for safeguarding people's data but also keeping them informed about how the data is going to be used, shared, or processed. After all, people have a right to know how their data is going to be used, right? So, for example, privacy policies by websites or other intermediaries inform users that their data may be used for determining their preferences, the kind of ads they'd like to see, the kind of content that they would like to see. Uh, that and if the bill is enacted in its present form, companies that collect data will no longer be required to publish privacy policies, right? Because SPDI would be gone, and this would result in a lack of clarity and informedness for users. So I recommended that the bill include a provision which requires companies to have a privacy policy in place. Further, the present bill requires entities that collect data to adopt reasonable security safeguards to prevent breach of data in their possession. And this provision, I believe, lacks specificity, as it should specify what kind of safeguards need to be adopted, right? It, in fact, is in sharp contrast to the SPDI rules, which clearly laid down certain standard codes such as the IAS, ISO, or ISC, which are to be adopted by entities to safeguard their data. And the bill in this respect is even different from the GDPR, right? The General Data Regulations of Europe, the GDPR, which lays down certain specific provisions for certification of standards that would be adopted to safeguard data. So I feel that this could be a problem, as not having security practices of a certain specific standard or quality in place may put user data at risk. So I recommended that the bill lay down certain specific standards, right, and not just in any kind of security standard, which should be adopted by companies to store and safeguard data. So these were my recommendations with respect to the SPDI rules, the omission of the SPDI rules by the bill. And now let me talk about some other aspects of the bill, which I believe needed a little bit of fine tuning and regarding which I sent in recommendations. So the one is the right to be forgotten, right? The proposed bill recognizes the right to be forgotten. It calls the right to correction and erasure of personal data. So this means that one can have data about themselves removed from the web. And this is a very welcome move, as this right has been often been recognized by courts in India and around the world. However, jurisprudence around the subject has duly recognized the need to balance this right with other rights, such as the right to know and the right to freedom of speech and expression. So let us take an example of a person who has been convicted of an offense, such as drug dealing or rape. Now, if such a person has been wrongly convicted of an offense and later acquitted by the court, he should have the right to have news articles about this commission of the offense removed from online portals and data servers. But if it is found that he really was guilty of the offense, the public then has a right to know about the same, and the media has a right to report on it. In which case, that person should not have the right to have this data erased from the web or from public servers, right? And this is where the GDPR, puts in specific exceptions, such as the right to freedom of speech and expression, public interest, or compliance with legal obligations to to this right to be forgotten, right? It puts these exceptions in place. And I also recommended that these exceptions be incorporated in the present privacy bill also for India, so that the right to be forgotten is not construed to be an absolute right. So there are some other recommendations also which I made regarding the penalties that are prescribed under the bill. So now the bill prescribes some very arbitrary penalties, such as very, very high upper limits in its schedule, right? It prescribes that a penalty of up to rupees 200 crore or up to rupees 150 crore or up to rupees 10,000 be imposed. Now, I am of the view that the penalties are rather arbitrary and non-specific. I thus recommended to the ministry that rather than laying down broad upper limits, the bill should lay down specific ranges of penalties for different non-compliances, which should be very well reasoned, and this would make compliance realistically possible for companies that collect data. And then I also made some recommendations regarding data portability. This is one of the last issues that I would discuss today, on which I made recommendations to the mighty. So there is no provision on data portability in the Digital Personal Data and Protection Bill. Now, what is data portability? Data portability is a feature which allows data to be moved across different applications or programs. It is very surprising that there is no provision on data portability in the new bill, considering that the same was present in previous bills on data protection in India and is also there in the GDPR. So I recommended that a similar provision on data portability be incorporated in the present bill to address this gap, as data portability greatly empowers people by giving them great control over their own data and its usage. So that's about it as far as Digital Personal Data Protection Bill and my recommendations regarding it are concerned. I hope that you got some valuable insights from today's episodes on privacy law in India and the latest bill on the same. As always, I would be happy to get your feedback and answer your questions in the comment section of this post. So please stay tuned for more episodes on intellectual property and technology law developments in India and around the world, and have a great day. Thank you.